Good day everyone. I am Jamal Marie Fabria from Gumhan, Pinas, Monga del Sur, and a student of GRMSU taking a course of Bachelor of Science in Criminology. For today, I will be discussing to you the role and function of the prosecution in the Philippine criminal justice system. The criminal justice system essentially is the system or the process in the community by which crimes are investigated, and the persons suspected thereof are taken in custody, prosecuted in the court, and punished if found guilty. Provision being made for their corrections and rehabilitations. Prior to the advent of American sovereignty in the country, we had the Spanish law on criminal procedure. The Royal Decree of September 4, 1884, by the virtue of which the penal code enforced in the archipelago, as amended in accordance with the recommendations of the Code Committee and its accompanying law. The provisional law on criminal procedure were published and applied in the Philippines pursuant to the Royal Decree December 17, 1884. It became effective 4 months after its publications in the Gaceta de Manila. In addition, the compilation of the laws of criminal procedure in 1879 and the law of criminal procedure of 1882 also form part our law on the subject. During the American occupations, General Otis issued General's Orders No. 58 on April 23, 1990, which was amended at various times. Some of the amendments were Act No. 194 providing for preliminary investigations, Act No. 440 relating the counsel's de officio, Act No. 590 providing the preliminary investigations by the Justice of Peace and Provincial Capitals, Act No. 2667 prescribing the procedure of cases originating in the Justice of the Peace Courts to the Supreme Court, Act No. 2709 regarding the exclusion of the accused to be utilized as government witness, and Act No. 2886 changing the name of the party who should prosecute the criminal action from the United States to the people of the Philippines. The Philippines criminal justice system is composed of 5 pillars, namely law enforcement, prosecution, judiciary, penology, and community. The Philippines criminal justice system is composed of 5 parts of pillars, namely the law enforcement, prosecution, judiciary, penology, and the community. So, the very first pillar is the law enforcement process. The law enforcement consists of the officers and men and the Philippine National Police or the PNP, the National Bureau of Investigations or the NBI, and the other agencies which learn of the commission crimes or discover them. Their duty is to letter A. Investigate the crime which take the form or surveillance and observation of suspects, other persons and premises. Interviewing persons with knowledge and facts directly or indirectly connected with the offense. Taking photographs, arranging for entrapment, searching premises and person subjects to constitutional and statutory safeguards, and examining public and other available records pertaining to the persons involved and getting copies pertinent entries. The police officers, in other words, collect evidence for use it in the prosecution of the suspects and the courts. This may consist of the testimony of witnesses, including invited suspects, which are invariably taken down in questions and answers form. Writing and objects, gun, knife, weapons, used in the commission of the crime, clothing of the victim, and etc. So letter B, arrest suspects by virtue of a warrant of arrest issued by a judge on the basis of evidence submitted by them or under circumstances justifying a warrantless arrest. The instances when an arrest without warrant may be lawfully effected by a peace officer or a private person as follows. Number 1. When his presence the person to be arrested has committed, is actually committing or is attempting to commit an offense. Number 2. When an offense has in fact just been committed and he has personal knowledge of fact indicating that the person to be arrested has committed it. And number 3, when the person to be arrested is a prisoner who has escaped from personal establishment or place where he is serving final judgment or temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. Any person who while in custody or otherwise deprived of liberty is under investigations of the commission of an offense has the following constitutional rights among others. Number 1. He must be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the service of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. Second, no torture, force, violence, threat, intimidations, or any other means which violate the free will shall used against him. Secret detention, places solitary, incommunicado, or other similar forms of detentions are prohibited. And last, any confession or admission obtained in violation of the foregoing shall be inadmissible in evidence against him. And letter C. Refer the case, the suspects, to the Office of Public Prosecutor or Municipal Trial Court of Preliminary Investigations or directly to the Municipal Trial Court. So the second pillar is the prosecution process. The investigations and prosecutions of all cases involving violations of penal laws are lodged with the Department of Justice or the DOJ through its National Prosecution Service. The DOJ is headed by the Secretary of Justice with the 3 undersecretaries assisting him. Aside from being the prosecution arm of the government, the DOJ shall have the following powers and functions. Letter A. Act as a personal law agency of the government and a legal counsel and representative thereof whenever so required. Letter B. Administer the probation and correction system. Letter C. Extend free legal assistance presentations to indigents and poor litigants in criminal cases and non-commercial civil disputes. Letter D. Preserve the integrity of land titles through proper registration. Letter E. Investigate and arbitrate untitled land disputes involving small landowners and members of indigenous culture communities. Letter F. Provide immigration and naturalization, regulatory service, and implement the laws governing citizenship and admission and stay of aliens. Letter G. Provide legal service of the national government and its functionaries, including government-owned or controlled corporations and their subsidiaries. And lastly, perform such offers functions as may be provided by law if consist the following constituent units. Number 1, Department proper. Second, Office of the Government Council. Third, National Bureau of Investigations. Fourth, Public Attorney's Office. Fifth, Board of Pardon and Parole. Sixth, Parole and Probations Administrations. 7. Bureau of Corrections. 8. Land Registrations Authority. 9. Bureau of Immigrations. And lastly, Commission of Settlement of Land Problems. The NAPROS is with the department proper, which is under the control of supervision of Secretary of Justice. It is composed of the prosecution staff and the Office of Secretary of Justice headed by the Chief State Prosecutor, the Regional State Prosecution Offices headed by Regional State Prosecutors, and the Provincial and City Prosecutions Offices headed by the Provincial Prosecutions and City Prosecutor respectively. The prosecution staff or state prosecutors perform the following functions. Letter A. Investigate administrative charges against prosecutors and other prosecution officer. Letter B. Conduct the investigation and prosecution of all crimes. Letter C. Prepare legal opinions or queries involving violations of the revised penal code and special penal laws. And last, letter D. Review appeals from the resolutions of the prosecutors and other prosecuting officers in connection with criminal cases handled by them. Regional state prosecutors have the following instruction. First, implement policies, plan, programs, memoranda, orders, circulars, and rules and regulations of the DOJ relative to the investigation and prosecution of criminal cases in his region. Second, exercise immediate administrative supervision of all provincial and city prosecutors and other prosecuting offices of provinces and cities comprised within his region. And last, prosecute any case arising within the region. Provincial and city prosecution have the following functions. Letter A. Be the law officer and province city as the case may be. He shall charge of the prosecution of all crimes, misdemeanors, and violations of city municipality ordinances in the court of such province or city shall therein discharge all the duties incident of institution of criminal prosecutions. Letter B. Investigate and or cause to be investigated all charges of crimes, misdemeanors, and violations of all penal laws and ordinances within their respective jurisdictions and the necessary information of complaint prepared or made against the person accused. In the conduct of such investigations, he or his assistant shall receive the sworn statement or take oral evidence of witnesses summoned by subpoena for the purpose. Letter C. Investigate commissions of criminal acts and take an active part in the gathering of relevant evidence. For this purpose, the National Bureau of Investigations, Philippine National Police, and the offices agencies of the government shall extend to him the necessary assistance. Letter D. Act as legal advisor of the municipality and municipality district of provinces or provincial or city government and its officers of the city. As such, he shall, when he so requested, submit his opinion in writing upon legal questions submitted to him by any such officer or body permanent to the duties thereof. Letter E. Assess the Solicitor General when so deputized in the public interest in the performance of any functions or in the discharge of any duty incumbent upon the latter within the territorial jurisdiction of the former, in which cases he shall be under the control and supervision of the Solicitor General with regard of the conduct of proceeding assigned to him and render reports thereon. The members of the NAPCOS are selected from among qualified and professional trained members of the legal professionals who who are proven integrity and competence and have been in the actual practices of the legal professions for at least 5 years prior to their appointment or have held during like period any position requiring the qualifications of a lawyer. These shall be appointed by the President of the Philippines upon recommendations of the Secretary of Justice. Once appointed, prosecutors are required to attend seminars, lectures, conventions, and continuing legal education to enhance their skills and investigations, and they enjoy a security of tenure because they can be removed from office only for a cause. Their appointments are not conterminous with the appointing authority, which means that even if the president who have appointed them is no longer in power, they shall still remain in office. In the discharge of their duties, prosecutors, guided by their credo and the constitutional mandate that a public office is a public trust and public officers and employees must all at all times accountable to the people serve them with utmost responsibility, integrity, loyalty, and efficiency act with patriotism and justice and lead modest lives. The prosecution process starts from the moment of the law enforcer and the complement of public office in charge of the enforcement of the law allied to have been violated files in case against suspected criminal, which is fleeing preliminary investigation would sit in the second stage in the life of criminal action is now in progress. The first stage is the police investigation. Preliminary investigation is the stage of which the public prosecutor evaluates the finding of the police or the evidence submitted directly by a complainant or public officer in charge of the enforcement of the law aligned to have been violated to determine if prosecution of the suspect in court is warranted. The rules of the courts define preliminary investigations as an inquiry or proceeding of the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime cognizable by the original trial court has been committed and the respondent is probably guilty thereof and should held for trial. A preliminary investigation is an important substantive right of persons suspected of crimes and deprivations of which in a tantamount in a deprivation of due process of law. It designed against hasty and malicious prosecutions. Preliminary investigation may be conducted by the public prosecutors or judge of the municipality circuit trial courts. The procedures in the conduct of preliminary investigations are as follows. First, filing of complaint and affidavits of witnesses by the police, complainant, or public officer in the charge of the enforcement of law alleged to have been violated. Second, personal examination of offense by the investigating prosecutor. Third, preliminary action by investigating prosecutor. Dismiss the complaint if he finds no cause to continue the inquiry. Issue subpoena to respondent requiring him to submit a counter affidavit. However, if no such counter affidavit is submitted, the investigation prosecutor shall solve the case on the basis of the evidence submitted by the police, public officer, or complainant. If a counter affidavit is submitted but there are matters which need clarifications, the investigations prosecutor may set a hearing to propound clarificatory questions. Fourth, preparation of resolution based on the evidence presented. The investigating prosecutor may prepare information if he finds cause to hold the respondent for trial. An information is an accusation in writing charging a person with an offense subscribed by the fiscal and filed with the court. Otherwise, recommended the dismissal of the complainant. However, in both cases, the approval of the provincial or city prosecutor of the chief state prosecutor of such recommendations is necessary. As regards offenses within the jurisdictions of municipal trial courts, no preliminary investigation is required by law. All the public prosecutor is required to do is 1. To examine the complainant of the supporting affidavit. Second, to personally satisfy himself that the affiants voluntarily executed and understood their affidavits and that the suspect has probably committed the offense charged. This examination and the determination he does ex parte, i.e., without notice, in the absence of the suspect, then he files the information directly with the court. At the preliminary investigations of a crime cognizable by the regional trial court, the respondent has the following rights. First, to have notice of the investigations and to have a copy of complaint, affidavits, and other supporting documents. Second, to submit a counter affidavit and other supporting documents within 10 days from notice. Third, to examine all the evidence submitted by the complaint. And lastly, to be afforded an opportunity to be clarification of certain matters is to be made and submit questions to the investigating officer for the purpose. It bears emphasis that aside from preliminary investigation, there is another type of investigation which a prosecutor may conduct, and this is what we call inquest investigation, which is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of warrant of arrest for the purpose of determining whether not said person should remain under custody and correspondingly be charged in the court. A respondent against whom an adverse resolution was issued by the investigating prosecutor is not without any remedy. He may file an appeal to the Secretary of Justice within 15 days from receipt of the questioned resolution. The third pillar is the judicial process. If the preliminary investigation results in the finding of the crime has been committed and the suspect is probably guilty thereof, the public prosecutor will file the corresponding information in the proper court, thus activating the judicial process. The case shall be then set for arrangement, which is the first stage of the criminal action. It consists the reading of the information or criminal complaint in court to the accused in open court. The accused is then asked how he pleads. The accused may plead guilty or not guilty to the offense charged. If he refuses to plead, a plea or not guilty will be entered for him. If the accused pleads guilty, the court shall sentence him to the corresponding penalty if it is satisfied of the voluntariness of the plea and the otherwise. Of the guilty of the accused, if the accused pleads not guilty, the case is set for pre-trial and or trial. The pre-trial shall consider the following materials. First, the plea bargaining. Second, stipulation of facts. Third, marking of identification of evidence of the parties. Fourth, waiver of objections to admissibility of evidence, and last, such other matters as will promote a fair and expedient trial. No urgement or administration during the pre-trial shall be used in the evidence against the accused unless reduced in writing and signed by him and his counsel. After the pre-trial stage, trial follows. The prosecution commences the presentations of evidence, followed by the accused. Prosecutions may present rebuttal evidence. The parties may also present written arguments or memoranda, after which the case is deemed submitted for decision. The law secures to every trial accused following rights during trial. Letter A. To be presumed innocent until the contrary is proved beyond reasonable doubt. Letter B. To be informed of the nature and cause of the accusation against him. Letter C. To present and defend in person and by counsel at every stage of the proceedings from the arraignment to the promulgations of judgment. The accused may, however, waive his presence of the trial pursuant to the stipulations set forth trial pursuant in hell bail bond, unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without any justiciable cause at the trial or particular date of which he had notice shall be considered a waiver or his right to be present during trial. When an accused under custody has been notified of the date of the trial and escaped, he shall be deemed to have waived his right to be present on said date and all subsequent trial dates until custody regained. Upon motion, the accused may be allowed to defend himself in a person when it sufficiently appears to the court that he can properly protect his rights without the assistance of counsel. Letter D. To testify a witness in his own behalf but subject to cross-examination on the matters covered by the examination, with silence shall not in any manner prejudice him. Letter E. To be exempted from being compelled to be a witness against himself. And letter F. To confront or cross-examine witnesses against him at the trial. Either party may utilize as part of evidence the testimony of witness who is deceased, out of or cannot with due diligence be found in the Philippines, unable to otherwise unable to testify. Given another case or proceeding, judicial or administrative, involving the same particles and subject matter, the adverse party having had the opportunity to cross-examine him. Letter G. To have compulsory process issued secure the attendance of witness and production of other evidence in his behalf. Letter H. To have a speedy, impartial, and public trial. And letter I. To have the right of appeal in all cases allowed in the manner prescribed by law. After the reception of the contending parties' pieces of evidence, the case is now submitted for decision which the court must render within 90 days after trial. If the court acquits the accused because in its view he innocent or his guilt is not proven beyond reasonable doubt, the case is definitely ended. Appeal by the prosecution is barred by the principle of double jeopardy. On the other hand, if it convicts the accused because it is viewed his guilt and the crime charge has been established beyond reasonable doubt, the latter may move for a new trial for reconsideration, which may be based on either of the following grounds. Letter A. The error of law or irregularities have been committed during the trial, prejudicial to the substantial right of the accused. Or letter B. The new material evidence has been discovered and produced at the trial, which it, if introduced and admitted, would probably change the judgment. The motion of the reconsideration may be based on the errors of law or fact in judgment. In lieu, or moving for a new trial of reconsideration, or after denial of such motion, the convicted accused may appeal to the Court of Appeals or the Supreme Court within the time fixed by law. If the appeal of the convicted accused is unsuccessfully and his conviction is unfirm, the case will be remanded to the court origin to the execution of the judgment. The latter court will be set a date for the accused to present himself for the enforcement of the judgment. At the time thus appointed, in court will issue an order or commitment, and the accused is passed on the next component. And the fourth pillar is the penal or correctional process. Punishment is the isolation of the convicts by imprisonment for the periods laid down by the courts or, in extreme cases, their execution by the methods prescribed by the law. Under correction and rehabilitations are functions undertaken by the institutions set up by the law. The Bureau of Prisons, Parole and Probations Administrations. And lastly, the fifth pillar, the community. After the convicts have passed through the correction component, either unconditionally as by full service of the term of imprisonment imposed on them, or by parole or pardon, they go back to the community and either lead normal lives as a law-abiding citizens in their barangays, or regrettably commit other crimes and thus go back through the same process and the stage of the criminal justice system. The community is at large through the appropriate legislative agencies, public and private educational institutions, parents and guardians, churches, religions, organizations, civic associations, and etc. And that would be the end of my discussions regarding the five pillars of the Philippine justice system here in the Philippines. And hope you enjoy watching it. Thank you very much. Once again, I am Jim Almer E. Fabria, a student of JRMSU, a first year college taking a course of Bachelor of Science in Criminology, and God bless.